Although employees have a legal right to strike, an employer has a corresponding right to replace striking employees permanently. What happens if striking employees want to come back to work, but they've been replaced? That's the question in Laidlaw Corporation. In a conflict over wages, Laidlaw Corporation's union employees notified the company that they would strike on January 12th. The day before the planned strike, Laidlaw's plant manager warned employees that if they went on strike and were replaced, they'd lose their right to employment at Laidlaw forever. William Massey joined the strike on January 12th. On January 14th, Massey unconditionally requested reinstatement. Laidlaw told Massey that his job had been filled and that if he were rehired, it would be as a new employee at a lower pay rate. 4 days later, Laidlaw called Massey and asked him to return, because Laidlaw had a new vacancy in Massey's department. Laidlaw offered Massey his previous pay rate, but said he'd be treated as a new employee regarding seniority and benefits. Massey refused this offer and remained on strike. On February 11th, the strikers as a group made an unconditional request to return to work. 40 strikers submitted written reinstatement applications that day. Laidlaw informed these strikers that they'd been permanently replaced and weren't entitled to reinstatement. Several other strikers submitted reinstatement applications over the next 10 days. Laidlaw rehired these applicants if the company had vacancies on the day they applied, but began sending termination notices to strikers who weren't reinstated. Simultaneously, Laidlaw was advertising job openings and hiring new employees because of turnover. Laidlaw never checked previous reinstatement applications before making new hires. The union filed charges with the National Labor Relations Board based on Laidlaw's failure to reinstate the strikers. The trial examiner ruled for the union. Laidlaw appealed to the board.